Well, thank you very much, Professor Scarza, for those kind words. I'm not quite sure that I'll be able to continue after that. I have to recover. But thank you so much. Well, I'll get right down to it, if I may. It's my thanks, of course, to Professor Scarza and Professor Martin Bariteau and their team at the University of Ottawa for organising this event, and particularly for inviting me to give this morning talk. Although I'm not sure I can quite live up to the billing for it, but I'll do my best. It's high time we did take stock of where Canadian trademark law stands today and what changes to it might be useful for the decade and, as the decade and century advance. Trademarks are, of course, central features of our market economy. Firms spend millions creating and promoting them. Consumers rely on them for their purchasing decisions. Trademarks may be a bit harder to bring into being legally than is a copyright, although much easier than a patent or design. But they can work better for their owners than either a copyright, patent, or industrial design because they last potentially forever, so long as they're used and renewal fees are paid when they're registered. So trademarks can continue well after a firm's other intellectual property has long expired. And franchisees like Coca-Cola and McDonald's, of course, would have very little value for their shareholders and franchisees if they didn't have trademarks that they could enforce against encroachment. So I think that Professor Scarza and Martin Bariteau have chosen their moment well. We have had stakeholder groups bending the government's ear, figuratively, with their parochial concerns, talking about counterfeits and border controls while lacing their conversation with exotic places like Nice and Madrid. We also have had parliamentary committees going for the bigger picture, but all this chatter has only poorly highlighted some basic issues of trademark law and policy that deserve to be more fully aired, and I'm glad that this conference is going to be airing many of them. While I was preparing my talk, I decided, and this could only be someone with serious problems, to pick up and reread the current Trademarks Act with its patchwork of yet-to-be-proclaimed 2014 amendments. Not a pretty business, even for a trademark aficionado. As I ploughed on, the words of Fred Rodell in a well-known article entitled "Goodbye to Law Reviews" kept recurring. Rodell was retiring as a law professor at Yale about the time I started teaching law as a youngster in the early 1970s. Some 80 years ago, he described legal writing in these words, which should be printed on a decal and affixed to every law journal editor's computer. "There are two things wrong," said Rodell, "with almost all legal writing." You notice he said almost all because you can't undercut your own article that you're just going to write. So there are two things wrong with almost all legal writing. One is its style, the other is its content. That, I think, about covers the ground. That about covers the ground for Canada's trademark law too, except I would add a third thing, its process. That is how the law got to have the style and content it has. So my talk is going to be about the content, style, and process of trademark legislation and reform as they are and should be as the century advances, as seen from the perspective of someone who uses or is affected by the trademark system. In England, that bemused person would be a subclass of the now rather dated man on the Clapham omnibus. So in Ottawa, perhaps we should talk, and today perhaps more than any other, of the skater on the Rideau Canal, perhaps, who uses and is affected by the trademark system. That reasonable skater could no doubt also be a lawyer, although we should remember that lawyers are merely the law's mechanics, not the people that keep the law turning, not its owners. So first, without getting into heavy academic theory, and I'm sure there'll be plenty of sighs of relief around that, let me suggest some ideas about trademarks and intellectual property that should shape our reasonable skaters' thinking and that I hope are relatively uncontroversial. First, IP law is an entirety. I originally wrote IP law as a whole, but with a W, but I decided to ditch that to remove the oral ambiguity, although the other one may well be as accurate. Anyway, law is trademarks law and IP law. IP law is an entirety, and trademarks law is just a part of it. Trademarks, like other intellectual property, can be called a type of property, but we shouldn't let the property label drive our thinking and become an end in itself. Thirdly, trademark law, like other IP law, is an exception to the general rule of free trade and competition, and any cut down of the general rule has to be justified. Fourthly, trademark rights, like other IP rights, require to be balanced. That is, the law must recognize and fairly reconcile the rights and interests of trademark owners, trademark users, and the general public. Fifthly, intellectual property law should reflect a coherent, joined-up policy of all its parts, and that includes trademarks law. Integrating trademark law into that joined-up IP policy should be a priority. So let me elaborate on those points initially before I get into the less controversial, perhaps more controversial part of the talk. Trademarks and IP can be called a type of property because they have value. Oh, maybe I won't go into that. Maybe I've really skipped a page. Let me just talk about the IP as an entirety point. So IP law is an entirety, and trademark law is but a part. Trademark law is not an island unto itself, despite how we seem to go about legislating and reforming it, or indeed other IP rights. Trademark law is part of the entirety that is IP, or more fully and accurately, the law of industrial and intellectual property. The rationale for each right may not be identical, but they are all designed to support innovation, a current government priority. In brief, patent law supports practical inventiveness, copyright law protects artistic, musical, and literary originality, industrial design law encourages originality in product design, and trademark law enables and enforces accurate branding and deters marketplace fraud and confusion. Structurally, however, the rights share various characteristics, just as is true of other fields, such as contract law. All contracts share common principles relating to formation, non-observance, enforcement, with specific provisions to regulate particular species, such as consumer and insurance contracts. IP law can be looked at exactly in the same way, as one that shares common principles of ownership, registration, transfer, licensing, enforcement, with specific provisions regulating how its components, trademarks, patents, copyrights, designs, and the rest, are acquired and what rights attach to each. It's perhaps ironic that in practice, the government and private sector alike tend to regard IP in this unitary way, while reasons of history and inertia cause IP laws themselves to regard IP's core unity only spasmodically. We legislate for trademarks without thinking much about how similar issues are treated in copyright and patent law, and we act similarly when we legislate for those laws too. Whatever values legal coherence and tidiness, whoever values legal coherence and tidiness will find IP law and trademark law's place within it dispiriting. Well, they are a type of property, as we know, because they have value and can be bought and sold, but we shouldn't let the property label drive policy and become an end in itself. This form of tangible property, as everyone knows, differs radically from the tangible property that is land and goods, and our rules must reflect that. If you take my bike, I don't have it anymore, and I have to walk or drive or get a cab or a bus. But if you take my trademark, I still have it, and I can go on using it and selling my goods and services. With it on it, you have simply interfered with my marketing, and the question is whether you can get away with it. Even the criminal law recognizes that deliberate trademark infringement is punished as fraud or forgery, not theft. Trademarks, then, if I come to my third point, are an exception to the rule of free trade and competition. IP is not part of the natural order of a free market economy, such as Canada's. Free competition is. Free competition with low barriers to entry is usually considered the best way to bring to the public the goods and services it wants. Usually is not always. Exceptions to free competition are sometimes justifiable for overriding public policy reasons. But to be legitimate, the exceptions must always be justified in fact. They should remain exceptions and not swallow up the rule. Trademark law as a whole can be justified as an exception that causes desired goods and services to be produced and distributed the way the distributor and consumer intended more accurately than would occur under conditions of unrestrained competition. It prevents fraud and confusion. But it does not follow that particular features of trademark law can be justified as an acceptable exception to the rule of free competition. I only need to mention the doctrine of trademark dilution, or whatever you want to call it, the depreciation of goodwill, which allows trademark owners to stop even non-confusing uses of their mark that are likely to cause harm to their brand's image. This doctrine in Canada and elsewhere has nothing to do with preventing fraud or confusion, and has inhibited such practices as comparative advertising that a free market normally encourages. Fourthly, the issue of trademarks unbalanced. Like any other specialists, IP specialists like to think that their field is the most important thing around. In reality, however, IP laws are like many other laws that give advantages to particular classes of person. The rights granted must be balanced off against the rights and freedoms taken from others by the grant. Thus, trademark law seeks to reconcile various rights and interests, the rights and interests of trademark owners, those of competitors and other traders, the rights and interests of consumers who rely on marks for their purchasing decisions, and the rights and interests of the general public which may want to consume the trademark itself in other ways. So trademark law and policy is about how best to achieve that balance and reconciliation. If trademark law, and this is my fifth point, is only part of the whole tapestry that is IP law, then the whole tapestry should have a coherent design into which trademark law fits. Trademark law is not even consistent within itself currently. For example, there is no general right to use a trademark for comparative advertising, as I've already just noted, but that right is granted for the use of geographical indications for wine. So I can't put a card next to a bottle of claret in the liquor store to say Chateau Vaver from the Okanagan is as good as Chateau Mouton Rothschild, but I can say Chateau Vaver is as good as any Bordeaux. Right, go figure. After asking why the Trademarks Act can't get its own story straight, our reasonable skater might well go on to ask why a single IP code does not exist that incorporates each head of IP with common provisions to deal with cross-cutting issues such as registration, transfer, licensing, correction of errors and enforcement, with special variations only for trademarks that are justified by special considerations that apply to trademarks. Sixthly, the joined-up policy issue. Joined-up IP policy should be a priority for IP law in general and trademark law in particular. So I would propose that we should be working towards a single intellectual property code that does exactly that, joins up the policy of the various areas so that they all march together in a common way without tripping over each other and pointing in different directions and generally making a complete mess of themselves. There are going to be three additional desirable features if one has that, at least three. First, it would expose each area of intellectual property law to the existing policies of the other. And it would raise questions of how far, if at all, those policies should apply across the board. For example, the Copyright Act has provisions indicating who owns the rights as between an employer and its employees. Doesn't the same policy on employer and employee ownership apply to trademarks? Why then doesn't the Trademarks Act deal with it? Going the other way, the Trademarks Act has a useful provision on remedies that gives courts a wide discretion to make any order that the court considers appropriate in the circumstances, unquote. And then lists as examples the usual schedule of injunction, damages account, and destruction of offending material. Flexibility in remedies has proved useful throughout the law in resolving cases in and out of court. Why do most other IP laws lack a similar discretion? Secondly, a single intellectual property code would add certainty and consistency to the law and so reduce the deadweight costs that uncertainty and inconsistency create. Because trademark law says nothing about employee rights, do we presume they differ from those in copyright? In a federal law that is supposed to apply consistently nationwide, do we relegate the issue to the individual law of the provinces, which may differ one from the other? Thirdly, creating a coherent intellectual property code would make intellectual property law more comprehensible and accessible, and thus acceptable to those whom it is designed to serve, both business and public alike, a point which I will return to later when I discuss questions of style. So let me turn to the content of trademark law, Fred Riddell's first point. Well, actually, no, it was the second point. He came with style first. But let me start with content first. I want to concentrate on the last point I made. If we accept that making Canadian IP law should reflect, if we accept that making it reflect a coherent joined-up policy is a priority, then we might ask first how a particular issue has been handled for other Canadian IP laws, and secondly, whether the same approach should apply to trademark law. The same policy might be presumed to apply at least where, for example, the issue was dealt with recently, no countervailing trademark policy is apparent, and the other intellectual property policy has worked satisfactorily. That is, there's been little adverse criticism, and any case law applying it seems sensible. The presumption of identity or similarity should weaken or disappear if any of these factors were missing. The process could work equally in reverse. How trademark law deals with an issue may reflect a policy that is equally transferable to other IP laws. So let me give you a couple of examples, fairly obvious examples, as how this approach might work. Take parody. In 2012, the Copyright Act was amended to allow copyright material to be parodied or satirized, so long as this was done fairly. Nothing like that appears in the Trademarks Act, and it should appear. The Trademarks Act was first enacted in 1953, as we know, well before Canada got its Bill of Rights in 1966 and its Charter of Rights in 1984, with their guarantees of freedom of expression. The Trademark Act looked after the free expression of trademark owners, but mainly dealt with those rights for others than trademark owners obliquely or partially. Comparable free expression guarantees in the South African Constitution led its Constitutional Court in 2005 to say that trademarks could be parodied despite the presence of unpropitious provisions in South Africa's Trademarks Act, much like those in Canada's. The court implicitly rejected the more restrictive view taken of free expression in Canada's Charter of Rights by our federal court in 1996. That court held that a labour union that infringed copyright by caricaturing the Michelin tyre logo in leaflets encouraging Michelin plants workers to unionise it was an infringement of copyright. The union escaped liability of a trademark infringement and dilution for a fairly obscure bunch of reasons, really, not particularly clear reasons. The best interpretation is probably that the union was using the mark to organise workers and not as a use that it was associated with any goods or services. Although one might say that organising union workers is itself a service. That's what the union applies for. And remember that the Trademarks Act allows unions to register trademarks. So I can't really sort of get too worked out about the correctness of that. But the result then is that any free expression rights for users that are protected by trademarks law appears obliquely. Right? It doesn't appear as a right in itself, writ large in the Trademarks Act. It comes out of a subtle process of interpretation, which is pretty much like working the tickets at Lotto. It arose obliquely from the way that the court interpreted trademark use. The recognition was partial and indeed arbitrary. The same parody could have been stopped depending on who did it and why. The Canadian Copyright Amendment was passed explicitly to overturn the Michelin decision on copyright. Parliament accepted that the right to parody and satire should be expressly stated, and users should not be forced down the expensive and rocky road of relying on the Charter of Rights, which had anyway proved useless in the Michelin case. Free expression rights have marched on in Canada, fortunately, since 1996, but the point of expense and relative uncertainty still holds good. If we adopt the formula I suggested earlier, then the case for amending the Trademarks Act to include fair parody and satire is clear. The copyright policy was implemented very recently. Whether a trademark is protected by both copyright and trademark law, or just one, seems irrelevant. And although no Canadian court has yet considered the new parody provisions, fair parody is accepted in most liberal democracies as protected expression that falls outside intellectual property law. The fact that the use is commercial, as we know in copyright law, is just one factor which is to be considered, not a factor which preempts all others. The second point I want to make here on cross-cutting issues and joint-up policy relates to user rights. Courts have not yet had the occasion or need to employ the language of user rights to describe what people other than the trademark owners can legitimately do with or to trademarks. The Supreme Court of Canada has, however, for over a decade consistently referred to so-called exceptions and defences in copyright law, fair dealing and so on, as user rights. The court has extended that idea to include the open space left by owner rights that are limited in scope. So to apply that notion to trademarks, the union rights to leaflet could be called a user right because the trademark use was defined, or that trademark use, the way in which it was defined, created a limited space where the union could act without being accused of infringement. I had more to say about user rights, but since I want to cover a bit more ground than I seem to be doing, and without speaking at a breakneck pace, I'll skip that, and if there are people who want to talk about that in the question period or later, we can do that. What I will say is that express user rights are harder to find in the Trademarks Act than they are in the Copyright Act. There are two short, lonely subsections hidden away at the end of a long list of user no-nos that allow some good faith use of geographical and personal names, some accurate descriptions of goods or services, and utilitarian features of a trademark. Those have changed almost not at all since 1953, apart from being renumbered. So my argument here would be that we ought to have a more consistent use of user rights throughout intellectual property law, and that would include trademarks. It would make clear that things such as repair is something that can be done by a user, something which you cannot actually find listed as such in the Trademarks Act. There isn't a provision that says you have a right to repair and sell a product under its existing trademark. We think the Act does in fact allow you to do that. It allows you to take your beat-up Ford Focus to the body shop, get it fixed and offer it for sale without having to strip it of its Ford and Focus logos. You might run into a problem if the car is totaled and has to be rebuilt, problem presumably not relating just to the car, or if you stick a Bentley grille on the front of it, as I have seen. Ford could, if it cared, stop you selling something that has been reconstructed or redecorated, even if you tell the seller what you've done. Some such result applies in patent and copyright law, and our best guess is that it applies to trademark law too. But shouldn't we say so explicitly? Why should we be bothered with cousining some result like that out of obscure language in the Act? It should be there front and center. It's because we've concentrated on the trademark owner's rights and not on what free expression rights other people have, that's where we've got to. Okay, those are just a couple of things I want to say or give you an idea of how content might be regulated. I'll come back to some more specific content points towards the end of my talk, but those are two major points that I think I want to make there. Let me say now something about style, the style in which the trademark law is written. Not a fashionable discussion, really. Our reasonable skater may think that trademark law is inherently technical and so has to be written technically and thus inaccessibly to others. And lawyers tend to think style is a pretty esoteric or minor concern anyway, so long as they can understand it, what the hell is the matter that nobody else does? Well, they're of course wrong on both counts. All law is technical to a point, but there are well-known ways to make it more comprehensible than it currently is. No one reads legislation for its entertainment or aesthetic value. One accepts that, except the occasional masochist or other seriously disturbed person, or I gather to say trademark lawyer, insofar as those are separate classes underneath. Anyway, laws are not written to be read like Shakespeare or Oscar Wilde or Baudelaire or even Christy Blatchford. Laws tell people what they can and cannot do and what could happen if they cross them. The law's style should therefore follow its function. So our reasonably literate skater who wants to get a trademark or not cross someone else's should be able to look at the Trademarks Act online and quickly get the sense of what she can and cannot do. Of course, she'll realize she'll probably need to go to a trademark lawyer or a trademark agent for advice on her particular circumstance, because lawyers do use words in funny ways. But the Act should, with a minimum of legal jargon, steer her in the right direction. It should be, in short, user-friendly. It is not, so far as its substance is concerned, as I've just shown. It's no better stylistically. There is more than just a matter of taste involved. The rule of law suggests that laws should be written in a user-friendly way so as to be accessible by the people, including our reasonable skater, not just their lawyers and judges. In particular, they should be written so that people whom they affect can read and understand them. People should feel confidence in their legal system. How can they if they can't easily understand the laws that affect them? Well-written laws are also good economics. They reduce the time and cost of working out people's legal position as well as the rate of judicial error. On this score, the Trademarks Act, even when drafted in the early 1950s, was a dismal failure. The added patchwork of current and about to be implemented amendments compounds its dismalness. The Trademarks Act may be only relatively dismal if you compare it with the Patent or Copyright Act or the Income Tax Act, but dismal it remains. Those are not terrific baselines. Why this state of affairs? Well, user-friendliness of legislation still seems to be a low priority with the government or parliamentary drafters. It was no priority at all when the current Trademarks Act was written in the 1950s under the watchful eye of Harold Fox QC, or perhaps the, some think, leading intellectual property specialist of the day. Fox made sure that the Act was better written than the legislation it replaced and than most other IP laws of the period. But again, that was a fairly low bar to clear. Fox and his committee were intent only in making the law understandable to people like himself. Trademark law specialist. He was uninterested in writing the law to be accessible even for non-specialist lawyers, or even non-specialist courts, such as the superior courts of the provinces that had jurisdiction in these cases, quite apart from the Exchequer and Federal Court later. So, where the literate commercial people who are using and paying for the system, where they were thought of, where they appeared in the scheme of things, well, they didn't. They were members, some of them were members of the committee, but the lawyers told them that, just be quiet, you can't understand this stuff, it's all legal. So in this curious system we have, those who pay the piper, the taxpayers and those who fund the trademark system through their fees, don't get to play the tune because they don't know what tune could or should be playing. This, after all, was the Fox who used to come to his IP classes that he taught part-time at Osgood Hall through the early 60s and prefaced them by saying he didn't know really why he was there teaching these students to take bread from his mouth. What, of course, is said in half jest reveals the speaker's underlying mindset. All professions tend to believe that their specialty is inherently complex and unable to be explained or properly understood by outsiders. That belief is as untrue of law as it is of other specialties. The jargon that lawyers and legal drafters typically use through second nature is often a major barrier to understanding. I want to give you an example because you may not believe how low we've sunk here. I'm going to give you a really simple example. I didn't choose this one particularly. I just almost random went to a section in the Trademarks Act, which is not particularly badly drafted. In fact, it's quite well drafted, according to Fox, and quite clear. If you're a lawyer and a trademarks lawyer, Fox's committee wanted trademark owners to feel that after registration they had a pretty secure title to their trademark. So the committee said that only someone with a better title could challenge registration. Any other Tom, Dick or Harriet was out of luck. So the Act allows a successful challenge only to someone who has earlier used or made well known a confusingly similar trademark or trade name without abandoning it by the time the trademark application was advertised. If the challenge comes after 5 years after registration, the challenger must also show the registered owner had adopted the mark in bad faith. That's with knowledge of the challenger's conflicting mark or name. Perfectly understandable policy. Lots of countries have that. I want to flash up, if someone can do so, the section there on the left. Section on the left is section 17 sub 1 and it runs into 17 sub 2, which we'll look at as a moment. The two of these sections run into, don't look at the right hand side at the moment, that's me. The sections on the left, as written, run into 185 words. The first sentence has 109 words with just 2 commas and no paragraphs. It's hardly fit to be read out loud or at all, but anyway, here goes. No application for registration of a trademark that has been advertised in accordance with Section 37 shall be refused, and no registration of a trademark shall be expunged or amended or held invalid on the ground of any previous use or making known of the using trademark or trade name by person other than the applicant for that registration or its predecessor in title. The first comma arrives. Thank you. Except at the instance of that other person or his successor in title. Now that you're taking breaths, here's one more. And the burden lies on that other person or successor to establish that he had not abandoned the confusing trademark or trade name in the name of advertisement of the applicant's application. 109 words, 2 commas, and those seem to have been stuck in just for fun. Now, Section 2, if we look at that, if we could go on to the next slide, subsection 2, is a bit better, but not much. Yeah. I won't read it. It's embarrassing. If we could flip back to subsection 1. Well, you say, criticize it, Vaver, that's terrific. Can you do better? Well, I say I can. And I say any half-competent drafter can do better. I don't hold out any particular expertise on it. You can put the thing, even using the current jargon of the Trademarks Act, and I'm not without it reducing the jargon. If the jargon can be reduced, it can be reduced. But even using the current jargon, you can do it better. And I try to do it better on the right. Now, if you disagree, I'll challenge you. I'll take out a glove and slap you. And we'll go outside and talk about it in hushed tones. But I suggest to you, when you look at the other section on the right, shorter, clearer, even using the dense language of the Trademarks Act, which I think can be reduced. If you look at the subsection 2, thanks, Florian, shorter, clearer, no loss of meaning, and I suggest the shorter it is, the more clear it is for the average reader. And I will guarantee to you that it doesn't change the meaning one bit. So, can we do better? I've used the word cancel rather than expunge. Expunge, a lovely word, should have been relegated to its Latin origins and left there in Latin. Cancel is the way we talk about things these days, and I think that was my major change, and I think it could be used throughout. I'd say the whole Act could be much easier to read if it were, and navigate if it was written those lines. Now, I hasten to add that I gave my original draft to my non-lawyer wife to look at, and she suggested a couple of things that weren't clear to her, and which I did change in my final draft. It took me an hour and a half, plus her comments, which took me another 5 minutes. But I suggest that as a very useful experience in itself, to hand over your legal drafting to a non-lawyer to look at. It can be a humbling experience, and it ought to be done more often by parliamentary drafters if they can find a willing partner, and indeed if anybody is willing to partner with them. So it should be so right throughout the Act. So why isn't it? Well, I think I've explained that enough. I think it just hasn't been a priority. And then you've had, over the years, additions, amendments, changes, different drafters, different drafting styles, no particular reason for that except the fashion of the times. When you had a consolidation, the consolidators just did very little minor amendments. They didn't do anything major. Does it matter? Well, hell, it does matter. Look, start with the title of the Trademarks Act. Professor Scars has already pointed out to you we've had major changes there, haven't we? We've gone from trademarks, 2 words, in 1953, to trademarks hyphenated in 1985. Why? Nobody knows. No one hyphenated marque de commerce at the same time, and would have been thought completely nuts if they had. But Anglophones seem to be more blasé about these things. But eventually we came back to trademarks, now a new one, together. One word, trademark. We changed all that. We still call it the Trademarks Act, plural, right? Like the Plant Breeders' Rights Act, plural. We call the Copyright Act the Copyright Act, singular, although there are many copyrights in it. We call the Patent Act patent, singular. We call the Industrial Design Act. Look, we can't even get the names of our blimmin' acts into the singular or plural consistently. What hope is there if we can't even get that done? Well, we should start. I'll give you a trivial example to show you the seriousness of the problem. We can't get even the most basic question right at the title. As we start the very first thing in the Act, we can't get straight. Of course it disintegrates after that. It just gets getting worse till the time you get to the end of the section, end of the whole Act, you're ready to be locked up. Standardizing the substantive provisions is, of course, the more pressing problem, since transactions frequently deal with IP rights as a whole, and differences in language among statutes are traps for both the wary and the unwary. Differences sometimes do mean differences in policy, but just as often they don't. The difference is stylistic only, but difference can and does give rise to costly, time-consuming arguments. And we know there are lots of areas, those of you who worked in IP will know lots of areas where this has occurred and where it's unnecessary. My favorite example, and I'll just be very brief about it, is a case called Beloit and Valmet, which went on for years in the 1980s through 1990s. But one of the points that was argued there was a Patent Act question, and the question was whether or not the naughty infringer had to pay over the profits it had made by infringing the plaintiff's patent. Well, the Patent Act didn't even clearly say that, right? The most basic thing is what remedy you get for infringement wasn't clear. The language it used was something like this, and I abbreviated, but not much. It says, the court could, on a party's application, in addition to damages, make any order it thought fit restraining infringement, quote, now I don't know what this means, or for and respecting inspection or account, and generally respecting the proceedings in the action. Now, only a lawyer and a completely berserk one could write stuff like that, and of course it comes out of the 19th century, and it stayed there in the Patents Act through subsequent amendments. Of course, the infringer says that applies. That doesn't mean he has to pay over anything. It just means that they had to keep accounts that would be helpful in assessing the damages. That's all. Just keep the bookkeepings, keep your books in order. That's all. The Federal Court of Appeal said that was wrong. It actually did mean you had to hand over all the money that you made from infringing, because that was the policy of the Act going back to the old 19th century general and previous, the old general law. Look, there was no difficulty in writing that easily. The Trademarks Act is clear on that. The Copyright Act is clear on that. The provisions there make it very clear what an infringer has to do if it has infringed in terms of remedies. This was not clear, and it gave rise to another layer of nearly $1 million worth of argument in 2 federal courts. And if you don't believe me, you go and look at the argument in the case. It's Beloit and Valmet, and it's in 1997. All right. Let me say one or two good words about the Trademarks Act, having slammed it. Compared to other Canadian IP laws and to the US and UK trademarks laws around in the 1950s, it was better drafted by their standards then. Fox did a good job then, and it was Fox's committee was the point was the Secretary of State for Canada in 1947 set up a committee to investigate the trademarks law, which it was agreed to be outdated. The 1932 law was even a greater mess than most others. The committee was dominated by trademark law specialists and business interests and chaired by the formidable Fox. It took 5 years to report after hearing from a broad range of stakeholders. Unlike the earlier UK committee, which it was modelled on, Fox's committee included draft legislation to implement its recommendations, which Parliament enacted, virtually holus bolus, with little debate. Little debate was also a feature of the 2014 amendments to the Trademarks Act for a slightly different reason. The amendments were contained in a bill called the Economic Action Plan, which was intended to implement the 2014 budget. That comprised one division, the trademarks part, comprised one division among 30 on matters ranging from income tax and refugees to a new bridge for Montreal and loans for apprentices. Trademark lawyers, of course, fruitlessly complained they hadn't been consulted on a bill that contained some major surprises, some of which we'll hear about later today. And they didn't get much time to ventilate their views through the committee stages of the bill, since it was a budget bill, as it proceeded to enactment unchanged. A process like that is unlikely to produce user-friendly legislation or any integration into a larger IP tapestry, and it didn't. One hopes it will never be repeated. Well, what should we be doing? Well, I think the model of another committee is a good thing, but it's, and I think that was what Daniel Bereskin, who some of you know and who knows more than one or two things about trademark law, suggested last year to the Minister of Innovation, Science and Economic Development. He suggested there should be another committee like the Fox Committee to look into the whole question of rationalising the Trademarks Act. I like the idea, but I would say that my preference would be for a broadly based committee, not just trademark law specialists and business interests, that covered the whole of IP with a mandate to produce an integrated, user-friendly law. That committee would include working groups that would deal with the various areas of IP, including trademark law. Mr. Bereskin proposed a number of trademark issues to the Minister that the committee should consider. Some are obvious enough. For example, everyone knows that an act that was drafted well before the advent of public colour television needs adjustment, just as copyright law did to the intricacies of the digital revolution and online commerce. I won't say anything about this, and I won't say anything particular about the 2014 amendments or the delay that's gone on in implementing them. We'll no doubt be talking about that later. Some things are likely to come up before the committee, and Mr. Bereskin in his letter mentioned some of them, and I borrow freely from them in my concluding remarks now, with his permission, and add some of my own. For example, a new act should contain a clear list of user rights to balance against the newly extended range of trademarks and enforcement provisions that trademark owners have received or are about to receive. The user rights should clearly reflect Canada's free expression guarantees. The Act should better recognise the cultural diversity, the much greater cultural diversity of the Canadian market than existed in 1953. Much marketing today targets consumers who are not merely French or English speaking. The current Act does not deal well with foreign language trademarks generally. If you read the Trademark Opposition Board proceedings, you'll find members proceeding as if significant language groups other than French or English can be disregarded. For some members, apparently Italian dictionaries don't exist unless they're handed one, and they apparently don't know without being told on oath that Italians enjoy vegetables, and that a good portion of the populace can actually read a Spanish language wine label. None of that seems to be accepted in the Trademarks Opposition Board, according to two decisions in 2012 and 2013. The new Act should deal better with marks in non-European script, such as Chinese, Hindi, or Arabic. Ang Shen Go, who is here with us, is writing a dissertation for an Osgood PhD on such marks, and has found that many are treated as designs rather than words, with unfortunate consequences when it comes to searching for conflicting registrations or raising questions of confusion. The new Act should deal better with trademarks that affect First Nations interests and sensitivities. We should have no repetition of the situation where the Nisga'a people of British Columbia were not notified of the registration of a mark called Nisga'a for clothing, and were indeed insultingly labelled by a trademarks hearing officer as a group known to relatively few Canadians, quote unquote. Not even relatively few other Canadians. The Act should consider whether marks such as the rude native, which was registered, with an equally tasteless drawing, should be allowed to be registered as trademarks as they have been for a restaurant. Trademarks raise access to justice issues, especially for small and medium-sized business. Mr. Bereskin says that trademark registration, opposition, and litigation can all become prohibitively expensive, and I rely upon him for that statement. But I would go further, and I would say, shouldn't the Act be changed to allow trademark infringement actions to proceed in small claims courts, as can occur currently for copyright infringement. At the moment, they can't, because the Trademarks Act leaves these matters only to superior courts and the federal court. And we have actually decisions where people have tried to take a trademarks infringement action before a small claims court and been sent packing. Even there, things are not that wonderful because small claims courts have limited jurisdiction. They can only award damages. They can't award, for the most part, injunctions or delivery up or anything like that. So there ought to be changes there if we're interested in access to justice. We all know of the situations elsewhere where IP is access to justice issues in relation to IP have given rise to whole new courts to deal with it. I'm not suggesting that. We have an existing structure. We should be able to handle it within it. I won't say much about the system of official marks. What hasn't been said about them that hasn't been said before, they shouldn't be around, at least as broadly as they are now. I mean, it's all very well starting off with flags, symbols, and all that stuff, but every thing that can call itself a public authority, loosely defined, and its dog have got in on this act, including, you see, the University of Ottawa, right-hand bottom, Section 9 notice on that, by the way. My favourite, not a reported case, is the Supreme Court of Canada, which is a notice in respect of its building, and which it used in order to try and close down a picture of the Supreme Court building in a legal journal. Unsuccessfully, I may add. But the Act, of course, says that can be done even if there has been no suggestion of endorsement or confusion or anything like that. I mean, anyone reading a legal journal with a picture of the Supreme Court building on the front isn't rationally going to think the Supreme Court of Canada is going to be endorsing every opinion in that thing, which is including the ones that are critical of them. I mean, you have to be balmy. The only surprise here, of course, is that this official mark system is taking so long to get rid of. I know Professor Scarza has had a go at it, helping in a private member's bill be drafted for it, but it hasn't got anywhere. And I guess it's the old story. Once you've got a right, once anybody gets a right, however spurious, no one likes to give it up. The committee should consider whether trademark dilution should be allowed to continue in the Act at all, or in a more restricted form. That doesn't unduly interfere with free speech. The Act should also consider, and I know we're going to be talking about this later, the scandalous, obscene, or immoral marks provision. Here's the consistency point. Scandalous, immoral, obscene marks are also not allowed on the Industrial Design Act. They are allowed, you can have a scandalous, immoral, or obscene work that is subject to copyright. Copyright, since 1921, it takes on board every scandalous, immoral, and obscene work and protects it. Modified on relation to remedies, but it's not left out completely. Ditto with the Patents Act. The argument is simply that if you want to regulate this, you regulate it through the criminal code or Twitter. I point out to you, in any event, the guidelines did not stop the registration of the rude native trademark. And if we are intent on doing things which are helpful to First Nations, we need a more targeted provision than scandalous, obscene, or immoral. Well, I think that's probably all that I have time to say, and I think I've overrun your patience. Let me just conclude by saying this. Georges Clemenceau once famously said, La guerre, c'est une chose trop grave pour la confier à des militaires. Well, trademark law is probably too serious a thing to entrust to industry or trademark specialists or academics alone. Perhaps we need to get the reasonable skater on the Rideau Canal to glide over to help Canada once again lead the world and set new standards with its trademark registration, and no death spirals, please. Thank you very much.